legal analyst Mpumelelo Zikalal. He's standing by to help us make sense of these legal developments. Thank you very much for your time this morning. So what do we need to understand about bail processes? Is it typical or is it unusual, for instance, to have a witness? Because one would think that maybe is reserved for trial stage.
No, not at all. Good morning to you and also to the listeners. In fact, bail proceedings are simply there to then say, we as a state have got an overwhelming evidence that this person should not be released. It's not in the interest of justice that they are released. There are certain instances or evidence that hasn't been collected as yet. And if it's released, there's a likelihood that it's either going to tamper with that evidence or tamper with those witnesses. So it's not going to be interest of justice if they're released. Instances of public safety are then looked at. Instances of whether this person is likely to evade trial will also be looked at. Instances whether the objectives of justice are going to be undermined are also looked at. Now, the reason why the state would go into the details of how this particular operation took place, they are then saying, we are not dealing with an ordinary criminal here. We are dealing with the mastermind who has taken time and effort and also used a lot of money to make sure that they're able to get what they want. So court, if you release them at this stage, we don't know whether we'll be able to get them. Take into account that we only saw them or we were only able to catch them in Tanzania, not in South Africa. So think about that before you release them. While on the other side, the accused will simply say, my Section 35 rights are still applicable. I'm innocent until I'm proven guilty. There are certain things, or if depending on the individual profiles of the accused, I haven't been arrested before, there are no pending cases. The witnesses in which you are alleging that you have collected is already within your coffers, so I won't be able to have access to them. Release me so that I'm able to continue. My rights to be regarded as innocent are still applicable. That is what the state will have to do. But the amount of overwhelming evidence which is coming in does place a very big burden on the accused to then say, what are the exceptional circumstances that we need to stage or that you are going to provide to the court, stating that you ought to be released. So we are not dealing with just ordinary evidence. Then we need the cherry on top in terms of in evidence matters of saying, these are the instances in which we are saying, provide what we are looking for, or in that basis, the release of the accused will be in the interest of justice. Failure to provide such, then you must stay in jail up until your trial is concluded.
If the Senzo Mewa trial or any other trials of lay persons is anything to go by in terms of delays or the amount of time it has taken, will these witnesses that are now giving evidence during this bail application process be then called upon again? What happens in the interim? Let's say, for instance, this takes another 2, 3, 5 years to actually go to trial. Someone perishes during that time or someone is not available. What then happens?
In fact, you're leading into the strategy which I saw one of the accused, I think it's Dr. Makurubani, taking in terms of saying, let me take a step back. Let me hear what the state has got up its sleeve in terms of the type of witnesses that it's bringing here, so that I'm able to prepare my defense and submit my application in a manner which is able to suit them, or will be able to dispute whatever that they are saying. Now, in terms of the witnesses which are giving evidence now, because you're under oath and you provided that witness the evidence, you must be able to regurgitate it as it is or is similar in a particular manner. So there are no contradictions that must take place at a later stage, because you'll be accused of lying. And the most important question would be, are you lying now or did you lie at an earlier stage? So it does work to the advantage of the state in terms of bail proceedings to say, this is the overwhelming amount of evidence that we have. It does help the state in terms of locking that evidence. So if the person would end up dying, then it's easier for the state to say, court, please take into cognizance the evidence which was provided earlier. Either it is disputed by the accused or it's not disputed by the accused, which is the position that we want to be in. But nonetheless, it is going to be recorded. And when we're looking into the entirety of the evidence that has been provided, it is going to make a very valuable contribution to your understanding and the determination of what we need to prove as a state. So it does place them in an advantage if that particular witness is later going to come back and provide accurate, similar evidence with no contradiction whatsoever, because it proves the credibility of the witnesses and also the sequence of events in which they are alleged. So it may help them depending on the performance of the witnesses that are there. But the manner in which they were narrating these particular stories, the manner in which everything has been done, the probative value, if you listen to it, you say to yourself, well, maybe they are correct. If there's other collaborative evidence that can be there, for example, bank statements, video footage, change in lifestyle of the accused that were there, it does seem to prove that whatever the witnesses are stating is actually the truth.
So it's safe to assume that this bail hearing will take quite some time in terms of a number of days, as was alluded to last week by the judge.
Definitely. Also, the amount of accused that are there is definitely going to elongate the time in which these proceedings are going to go by. Because every single accused has got to state their own unique exceptional circumstances in their whole bail applications. They all must be able to get cross-examination. They all must be able to get re-examination. If one of the accused is going to go into the witness box and actually provide evidence viva voce and provide an affidavit, certainly that's going to elongate these bail proceedings. So I don't think it's something which is going to take a short amount of time. It may be extended, but once that evidence has been done and collected and is within the court's discretion to then say, we are going to sit as the court, deliver a judgment in which either we are going to grant or deny bail. And we are guided strictly by the Constitution and Section 6. The most important question, is it in the interest of justice that you be released on bail? Despite the fact there's overwhelming evidence behind you, yes, this evidence is still subjected to be disputed at a later stage. However, let me weigh these things and let me see whether it's in the interest of justice that you be released.
Mr. Zikalal, what happens when accused or suspects are held in this situation, right? Then they haven't gone to trial, they're still in the holding cells. They appeared rather well taken care of, especially in terms of appearance. The one lady's hairstyle had even changed. The one gentleman had gotten a haircut from the first time we had seen them appear before the judge. So what happens when accused are being held as they wait to fight for their freedom?
The Correctional Services Act comes into play here because that's where they're being housed and that's the department is responsible for them. Let's differentiate between the inmates, people who have been fully convicted and are serving their sentences, and someone who's still going through trial. There's certain leniency which is there, which is perfectly allowed by the Act. So you would find that they may be even be brought in food in terms of their appearances. You can say, because I'm going to court on the very next day, can I be able to look presentable? Certain negotiations, and you can come to understandings with the people who are managing those particular facilities. But it does not mean that you should get access to the internet, access to phones, or anything which may jeopardize the safety of the operation of the Correctional Services Centre. But there is a bit of leniency in terms of what needs to be offered. Why is that so? Well, one may ask. Let's remember, these individuals are still considered innocent by our Constitution. So it is only when there's a court order that says, Mr. or Mrs. So-and-so, you are indeed guilty of committing this crime, in which you then fall under the inmate category, in which you then fall under the category in which you can't do the simple things that you and I have access to. You simply to fall under the provisions of the Correctional Services Act, and whatever benefits or things that you may be allowed to have are governed by that particular act.
Okay. Thank you very much for your time and helping us make sense of all of that. Mpumelelo Zikalal is a legal analyst.